All right, Mr. Alvarado, you are charged with violation of a domestic violence injunction. I've reviewed the charge. The bond is currently at none. I'm going to stay the bond at none. You can see the judge to whom this case is assigned about a bond. I'll appoint the office of public defender to represent you. Thank you, sir. Next, I have Esther Armas Nieves. All right, Ms. Nieves, I have 5 probable cause for the charge of battery. Do we have the victim here that wants to be heard? Do we have any input from the victim, State?
No, Your Honor.
All right. All right, bond is currently set at none. I'm going to set bond in the amount of $500. Does the defendant and the victim reside together? Do they have children together?
One moment, Your Honor. Your Honor, they do reside together and they do have one child together.
Okay. All right, what I'm going to do is I'm going to set bond in the amount of $500. I'm going to require no contact with the victim in this case. They're to maintain separate residences. The defendant can return to the marital home one time with law enforcement to collect personal effects. Should the defendant want to modify those terms and conditions of release, that can be brought up with the judge to whom the case is assigned. All right, thank you. Next, I have Booker Austin. Mr. Austin is charged with retail theft. It is a petty theft amount, but a retail theft with 3 more priors, which makes it a felony. I find probable cause based upon the charging affidavit. I'm going to reduce the bond from $2,500 to $1,000. Does Mr. Forgot to ask whether the previous folks wanted the appointment of the public defender. Does Mr. Austin want the appointment of the public defender?
Mr. Olson did fill out an application, Your Honor.
All right, I'll appoint the office of the public defender to represent Mr. Austin. I'm also going to require that he, as a condition of his release, not return to the location of this offense.
And Your Honor, Ms. Armas did fill out an application as well.
Your Honor.
All right, I'll go ahead and appoint the public defender, Ms. Armas. I moved a little too quickly. Yes?
Your Honor, this is Officer Hernandez with pretrial release. Are you going to take any action on the Osceola case 24 CF 1309 that he's out on probation for a petty theft?
I overlooked that. Bear with me 1 minute. Thank you for bringing that to my attention.
No problem, Your Honor.
Oh, yeah, look at that. On probation. Same offense. All right, so so he's currently on probation. Is he? All right, so my options are to,
Your Honor, if I may briefly.
yes.
I just say I don't know Mr. Olson's previous representation, however, just from my observations and interaction with him today, I do think there is a possible competency concern. If Your Honor would be willing to take no action on the violation of probation, I think that might be due to a competency issue.
Does he have something, he's on probation in Osceola County 24 CF 1309?
Yes, Your Honor. He's on state probation for that offense from Osceola.
All right, you know what, I'm going to take no action on that, and his probation officer may choose to violate him on that. But this time I'll take no action.
Thank you, Your Honor.
Thank you. Thanks for bringing that to my attention. Feel free to speak up if I'm overlooking something. All right. Amanda Bentley Scott.
And Your Honor, I do have a PC and a bond argument for Ms. Scott.
All right. All right, go ahead and make your PC argument.
Yes, Your Honor. As to the burglary, in the four corners of the affidavit, there does not appear to be any intent to commit a crime therein. There is no evidence that Ms. Bentley Scott intended to commit a crime when she actually entered, like when she entered the home. There's no indication of what her intent was when she did that. The fact that a crime did then occur after the fact does not indicate that she had an intent when she entered the home.
State?
Your Honor, for this particular charge for the burglary with assault and battery, she remained in the home despite not being invited in and committed the crime. I think what defense is getting at is more a potential defense of some sort. As to the four corners of the affidavit, it's clear that she entered in there with the intent to make contact with the victim. So it's clear PC is found for this particular charge as when she was in there, she further, the victim is saying that he observed her throwing items in his living room when he was not in there. And so she clearly entered with an intent to commit either the crime of criminal mischief, perhaps some sort of later assault. So it's the state's contention that she had the intent when she entered the building. Further, this particular charge is a pretrial detention hold, and so that's what state would be asking she be held under.
Be held for pretrial detention hearing?
Yes, Your Honor.
John, if I may briefly.
All right, I'm going to find probable cause on the charge of burglary with an assault or battery therein, and also battery. Did you want to be heard on release?
Yes, Your Honor. Ms. Bentley Scott has let me know that she's 5 months postpartum at this time and she's still breastfeeding. So I would ask Your Honor to take that into account when determining whether to release Ms. Bentley Scott.
Okay. Well, the state has requested a pretrial detention hearing. Do we know when that will occur, Madam Clerk?
November 19th at 8:15.
All right, I'll hold Ms. Bentley Scott until that hearing can be conducted. That's November 19th at what time? 8:15 before which judge? Whoever's going to be handling it. All right. But I will find probable cause on both charges and detain the defendant for pretrial detention hearing.
Thank you, Your Honor.
Thank you. Next, I've got Samuel Carter.
Your Honor, I do have a PC argument for Mr. Carter.
Morning,
All
Your
right.
Honor.
All right. Good morning, Mr. Carter. All right. Go ahead.
Yes, Your Honor. The identifying witness in this case was only able to say he, quote, could possibly, end quote, identify the suspect. He was not directly involved in the original interaction, and therefore I do not believe there's enough to find probable cause based on this very tentative witness.
Well, it says in about 2/3 of the way down, I was able to make contact with an employee, Carlos Giovanni Marrero Cerda, who advised he was there and saw the male who stole the green Jeep Wrangler, and could positively identify him. Does that change your argument at all?
No, Your Honor.
All right. State, do you want to be heard?
Your Honor, I think PC has been found, especially since the defendant was later found inside of the vehicle that was stolen from the
Okay, all right.
location.
I'm going to find probable cause. I'm going to stay the bond at $2,500. Does Mr. Carter want the appointment of the public defender?
Yes, Your Honor. Mr. Carter's filled out an application.
All right, we'll go ahead and appoint the office of the public defender to represent Mr. Carter. Good luck, sir. Carlos Cristancho Rodriguez.
He requires the aid of a Spanish interpreter, Your Honor.
Okay, put that off for Spanish interpreter. Next, I have Gregory Danner. All right, Mr. Danner is charged with possession of controlled substance, meth, and possession or use of drug paraphernalia. I find probable cause, I'm going to stay the bonds at $2,500 and $500 respectively. Does Mr. Danner want the appointment of the public defender?
At this time, Your Honor, yes.
All right, I'll appoint the office of the public defender to represent Mr. Danner. Thank you. Next, I've got Christopher Duncan. Mr. Duncan is here on a failure to appear. I'm going to find probable cause based upon the documentation receipt. I'm going to stay the bond set by the judge who he failed to appear in front of $4,000 and appoint the public defender's office to represent Mr. Duncan unless he's already represented on the original charge.
Are you representing the public defender? He'd like to keep the public defender, Your Honor.
All right. All right, thanks, sir. Alberto Labrada.
Your Honor, I do have a PC argument for Mr. Labrada.
Morning.
Morning. All right, you can go ahead and make your argument, counsel.
Yes, Your Honor. There appears to be enough evidence in this case for a finding of probable cause that client was acting in self-defense. The self-defense statute in the state of Florida means that a person who is defending themselves and standing their ground is immune from prosecution. Therefore, if PC for self-defense exists, there can be no PC for a crime occurring because Mr. Labrada would be immune from any prosecution.
All right, state.
Your Honor, again, that's just what's being asserted is a defense potentially to the crime committed. In this particular case, the victim states that a firearm was pointed at her, and so PC has been found for an ag assault deadly weapon.
Your Honor, if I may, quickly.
You may.
This isn't a defense, Your Honor. This is a immunity from prosecution. If he is immune from prosecution, then no crime occurred. There cannot be PC for an argument that he is immune from.
Well, that is an immunity argument that could be made, but looking at the four corners of the charging affidavit, I am going to find probable cause for the charge of aggravated assault with a deadly weapon. Is there a second charge? The way this is written is a little confusing. Or it's just the one charge? Because I show a bond amount of $1,500 and then one total of $4,500. Does he have
I
a
think
second?
it's the way Your Honor, I think it's the way he crossed it out. It looks like a 4, but it's,
Oh.
yeah, I think it's the weird way he crossed it.
Oh, you're right. You're right. That's exactly what it is. Thank you for helping me read that. I probably could not have figured that out. All right, it's at no bond. I'm going to set bond. I'm going to set bond in the amount of $3,500. I'm going to require that Mr. Labrada have no contact directly or indirectly with any witnesses or victims. And did he want the appointment of the Office of the Public Defender?
Not at the moment, sir.
I'm sorry, did not hear that.
Not at the moment, sir. I'm still looking to see if I can appoint someone getting out of here.
Okay, I think that's no.
Yes, Your Honor, it's a no. I apologize.
Okay, he can retain counsel. It's just the microphone's a little fuzzy there. All right, good luck, sir.
Thank you.
All right, next I have Shafa Mack. All right, I reviewed the charging affidavit. I find probable cause. I'm gonna stay the bond at $500.
Your Honor,
Yes.
pretrial release. He does qualify for direct pretrial release.
Okay. Would he like pretrial release or would he like a $500 bond?
One moment, Your Honor. He'd like to do direct PTR, Your Honor.
All right, I'll go ahead and release him on pretrial release. Mr. Mack, you're going to be provided with a bunch of instructions and requirements on pretrial release, a little bit more than